always making sure your client realizes that they hold the keys, not us.
Yes.
Where am I beholden to you? Where am I beholden to my employer? Where am I beholden to the plan? Where am I beholden to the participant? We try our best to be very clear and explaining to our clients, these are the things you should be thinking about before you ask me to go forward, so that if you're not informed, you are prior to making decisions that could be impactful.
Welcome to the Tao of Chao podcast, where we will try to find balance and provide a clearer path forward in this uncertain world. I'm excited to have Todd Levy on today with us as my guest. Todd is responsible for setting the vision of the RIA division of the firm TRPC as a managing director, and he is also the member of the firm's strategic leadership team. TRPC serves in a fiduciary advisory capacity across various business lines to include corporate defined contribution, defined benefit, and personal wealth management services. And here is Todd. Hello, Todd. It's great to have you on the Tao of Chao podcast, and thanks for being my guest.
Really looking forward to it, Philip. Good to see you as well. Thanks for having me.
Thank you. We have known each other for quite some time, and you know how we both are pretty fiduciary-centric. I don't want to say that we are nerds about fiduciary laws and rules and stuff, but we live in an environment where in an industry, shall we say, that we cannot get away from not talking about and thinking about fiduciary issues. And maybe we can start talking a little bit about how what you are doing now and the firm you are with, and how fiduciary plays a role in what you do and what your firm does. Because I think we'll go nicely to the rest of the content today, because it relates to many of the things that you and I both spend lots of time thinking about. So please go ahead, and maybe you can sort of give us a framework first.
So Philip, you know that I work for a company by the name of the Retirement Plan Company. The Retirement Plan Company is a retirement plan record keeper, also provides third-party administration and compliance services. In addition, the team that I work closely with and lead is on the investment advisory side, and whereby we provide discretionary and non-discretionary plan advisory services, as well as we provide wealth management services to individuals. So we're multidisciplinary. At times we're bundled. At times we unbundle our services based on the need of the particular engagement. But primarily we serve, or I should say the retirement plan company serves the small and mid-sized portion of the market. So anything from a startup plan to, say, a few thousand lives and a few $100 million. So those are the parts of the market that we serve. And I think, as you're going to kind of allude to, there's lots of moving parts across these lines of business. And sometimes they stay nicely in their own lanes, but other times they overlap quite frequently. So we do a lot of different and exciting things here, and it's definitely never a dull moment.
As you do what you do, you wear different hats. Because you could be, on the one hand, helping to serve as just a pure record keeper. As a pure record keeper, all you're doing is keeping record. That's what I call the record keeper. You keep the records so that plan participants can look how much they have in the, you get to give them the statements and do all that. You also do third-party administration, so you do all the discrimination testing and all the other things that the IRS and DOL require you to do.
Yep.
But you're not a fiduciary because you're basically a service provider.
Correct.
Then the next thing you could do is, you mentioned that you can be giving investment advice to the plan. You can do it in two ways. One is, I'm going to recommend to you to think about these things. You, Mr. Plan Sponsor, still make your own decision. The other is the plan sponsor say, no. Don't push it back on me. I can't possibly know how to do this. I know you are the expert. We want to hire you to make all the investment decision on a discretionary basis. Tell me which investment option we should have on our menu so that our participant can use. And if you accept that role, you are also a fiduciary. So you could be a non-fiduciary, or you could be a co-fiduciary, or you can be the discretionary fiduciary. And then God knows there are all the other things. How do you think about that when you go and you wear the hats? Do you get really self-conscious and say, okay, hold on, that's a lane. That I don't cross over that lane. Does it bother you, or does it become so natural? You know exactly what you're doing and how you're doing it.
Yeah, the way you say it, you're correct. It also sounds like, boy, there's a lot going on for someone to try and digest. And I would say in most cases, it's more singular, right? It's not all concurrent. But there are times where the role can change. There are times when multiple services can present, and those are the times where it's really incumbent upon us to be very clear with our clients, make sure they understand a new service is coming in, another service is going away, two services at once. Where am I beholden to you? Where am I beholden to my employer? If that's the case, where am I beholden to the plan? Where am I beholden to the participant? I think these are the very important parts of the relationships where, we try our best to be very clear, not only from a disclosure and a written standpoint, but really from a communication standpoint, and explaining to our clients, do you understand that our role, you're asking me to do a role that is different than the role I'm doing? Here's where my conflicts lie. These are the things you should be thinking about before you ask me to go forward, so that if you're not informed, you are prior to making decisions that could be impactful.
So you need to be forward thinking, sounds like. You need to have disclosure.
Yep.
And not disclosure in, tiny eight font or whatever, 8-point fonts, but really saying it, disclosing it to your client, and make sure your client understood what your disclosure is.
Yep.
And if he or she still wants to move forward, and you continue to have a duty, right, even after that, to make sure that your true north is in their best benefit when you are giving that kind of advice.
Yeah.
I'm not your compliance officer. You can relax.
Actually, I'm thinking about, Philip, a conversation we had many, many, many years ago, and I think the metaphor you used under this type of pretense was, always making sure your client realizes that they hold the keys, not us.
Yes, thank you for reminding me that. I normally tell my clients that no matter how comfortable you are with me, because we've known each other, and obviously you trust me, otherwise you wouldn't ask me to do the things and take care of your finances or your plan or what have you. You purchased my service. You're not buying a friend. I am your friend, but that's not the purpose of this relationship. I am honored to be your friend. But I think it's so important to have a slight tension between us. Is that tension that keep me honest, keep me on my toes, and they give me the very best that I know how. I literally say in those words. I don't know if clients always remember that. So, but I think it's not just for the client. I want to remember that I don't get too comfortable. I don't get slacky, whatever the term is, right? And that I am doing the best that I know how, not only through disclosure, but through our actions.
I think that behavior is actually something that we share in common. Like, it's for their benefit, but it's also for our own.
We have to be in check, because many times people with good intentions end up going the wrong place. So let's turn our attention a little bit towards without we don't intend to spend the entire on the fiduciary rule, but there's a new fiduciary rule, as you know. Mm-hmm. It came out, and it's going to be, it gave a period of time, and then it will be enforceable in September, unless, well, there's already one lawsuit. I think there are 2 lawsuits filed to against it, assuming it goes through. What is your understanding of the fiduciary? Why do they have that? Why are they doing this now, do you think?
Well, I think it's a conversation that's been ongoing for some time now, right? And they're yet to really settle in on how to deal with the issue that there are people out there that provide various different services that I think the public sees unilaterally, but in reality, there's differentiation. And there are fiduciaries and there are non-fiduciaries, but both operate in this investment industry and deal with participants. And I think there's times where both roles are quite appropriate. I don't think, unfortunately, I think it's hard for the public to differentiate those who are acting in fiduciary capacity or not, or have conflicts or not. And I think the government has tried to step into a really challenging position to draw those lines brighter. And I think it looks like the trend is, as opposed to separating, it's actually bringing more people into the definition to act and then be held to the highest standard when it comes to dealing with public and making recommendations for them. So I think that's kind of the big arc.
We look at it, I always try to think about how to explain it to a layperson.
Yeah.
Even when you tell people that I'm going to work as a fiduciary, they may barely understand the term. What does it really mean?
Right.
And so I don't remember who it was. Years and years ago, I was told, and I learned that this whole section of law called ERISA, that was 1975. So we're coming up, 50 years. That the idea was anytime that we are watching out and taking care of other people's money, we owe a duty of two duties. One is loyalty and due care. The second one is due care. And how's the framework? The framework basically says this is literally a lockbox. The money goes into this lockbox. You can never come back out, with some exceptions, obviously. And from a service provider standpoint, well, it's prohibitive to take any money out that is not yours. So then they give you exemptions to those prohibitions, so we say. So exempted from the prohibitive transactions is the way that ERISA operates, as I understand it. In other words, everything is no,
yes,
except this is yes, and that's it. That kind of thing.
Right.
So when you think in that framework, I think there may be a lot of criticism of late that 401k or 403b really haven't done good enough a job for America. Retirement industry in saving and in so on and so forth. But I think that ERISA, all in all, has put enough scare tactics into all the people who are touching the retirement assets.
Yes.
That I think it has a chilling effect and continue to have a chilling effect. Is it perfect? No. Has it weaned out everything? No. But has it really encouraged good behavior? I think overall I would have to say yes, if you agree. In theory, let's say I was 18-year-old, and after 50 years, I'm 68-year-old. I'm ready to retire. My normal retirement age, 67, let's say. And all of a sudden, I did all the right things. I accumulated, and my plan sponsor, my employer, is really good, and we got the right advisor, and everybody did the fiduciary thing. And now I have $1 million in there. I feel pretty good. And so now I have $1 million. And the moment I say I'm going to retire, typically I'm going to sell everything, roll it out of the plan into an IRA.
Mm-hmm.
At that time, I felt, wow, I've never had $1 million in my life. I feel good about it. I have no idea what to do with it. And this is where, in theory, the ERISA no longer applies because it's out of the plan.
Right.
And I think DOL is quite concerned that they have tried so hard in the last 50 years to protect me, both from myself as well as from bad actors. But yet, in one fell swoop, that $1 million walks out of the door and is no longer subject to all this coverage and protection, and it's like naked. And say, okay, yeah. come take care of me.
You got this, right?
I'm being facetious here, but I think that's some of the motivation of this new fiduciary rule. That even though we are coming to the end of this pension retirement, where I am party to, I'm ready to get out. This getting out process and post getting out process becomes the most vulnerable, and that they want to put some boundaries to it. They can't put enough boundaries because once it's left, it's left. But the decisions to leave and where it goes and what to do, they want to pull it back to make sure they still have the intended protection.
Yep.
Very long way of explaining that rule, even though none of what I said is actually in the rule, but that's what they are trying to do.
Certainly. I'll kind of just further expand there.
Yeah.
If you think about this, this retirement thing corporate, 401k or company sponsored retirement thing, it's really brand new when you think about the timeline. We don't have a lot of history with this. I mean,
Right.
so if you think about Social Security or traditional defined benefit plans, I mean, when they were built, life expectancy was even shorter than the date people retired, right? So
Right.
there really was
Right.
no payout. There was no retirement period. It was just an arbitrary date, and a lot of people didn't get there. As we move forward in time, the date of life expectancy still stayed very close to quote unquote retirement date. And
Yep.
now we're just really at the first real phase of the defined benefits are in the background. They're not in the foreground. Longevity is now materially longer for most people. And retirement is a very potentially sizable window for a large cohort. And now throw on top of the fact that the cohort we're talking about happens to be the largest demographic
Yes.
segment of the population. So
Yeah.
we've never really done this before. We're worried that all of this hard work and protections that were in place are at risk of being depleted. At the same time, we have a whole new set of needs that the government is really doesn't have anything to look back on and say, here's how to do it, here's the playbook. They're really figuring it out as they go. And I think they're struggling in a lot of ways to find that perfect calibration. I'm also not even sure it really is addressed really the need of the people, kind of where the puck is going from an income need. I mean, great, we protected people and now we've allowed them to be on their own, and we know they're not going to be violated in any way from a fiduciary standpoint, but they're still left with a big question to answer, which is how do I get through this non-income period of my life, income producing period of my life, and spend down my assets? I mean, geez.
That's right.
So I think whatever rule we get or don't get, it's not the end.
It's not the end. I agree with you. And I think there's a lot of part of the industry is fighting back.
Yep.
They felt that it's against a certain type of business models, which is primarily commission.
Yep.
They feel that the commission salespeople, especially in the insurance industry, tend to be the only financial advisor who's able to go to the smaller account and give advice. There are all kinds of pushback, but I think the concept is sound. I think it is an issue. I'm not going to sit here and say fiduciary rule is the only way to solve it. But there has to be some adult in the room.
Yeah.
And so far, through ERISA, they're pinning that adult as the plan sponsor. But once you leave the plan sponsor, there is nobody else that you're going to pin it on. So they're going to try to pin it on. Well, SEC already pinned that on to the advisors of the best interest standard, which is a lesser standard than the ERISA standard, but at least something.
Yep.
I think that is really really important to help individuals, and becomes a struggle between shall we keep our assets in plan or out of plan?
Yeah.
And we can do a whole hour of that, but just by itself, I can feel that. But we'll leave that alone for a moment. Because that's another decision. Is a decision. Do I want to leave my money in the plan, and is there a mechanism to me to access that money as some form of income for the rest of my life, or not? And would every employer feel comfortable to continue to take on the fiduciary responsibility of all the people who have ever worked for us, chose to leave their money with us? And I still have a fiduciary responsibility to make sure everything is okay. It's not a single answer. It's a double-edged sword to some extent.
A couple of things that are going on in my mind. One, I think we're old enough to remember a time where the brokerage model dominated the financial advice world, and the evolution that occurred to more of an investment advisory type of capacity, and away from the traditional brokerage model. And therein, really putting the individual, whether it's a participant or the wealth client first, really seemed to serve the industry well, and that was a tailwind from a regulatory standpoint. And I think we're just kind of crossing the next level, which is the insurance industry. It's going to serve a critical part in this phase. And I think there's a tremendous amount of opportunity for that industry to be very successful and a big part. But like the advisory business changed, I think we're probably in the beginning of a change cycle for the better for the end investor. We'll need to rely more and more on guaranteed vehicles.
Yeah.
And I think that will be a good thing, and I hopeful that the regulation will kind of narrow that into a path that's really the best direction for the industry and for everyone to be proud of, and really ultimately for people to be rewarded by.
So you're referring to really starting to talk about the 2019 Secure Act introducing the investment of annuity as an option, as an opportunity for individuals to turn assets into some kind of guaranteed lifetime income, which is what I suggest that most people, it's really what they're looking for. They don't know how to use those words. They don't say it that way. But a pile of money ain't going to be any good if it doesn't produce the kind of income I need to maintain a certain standard of living, and that I can rely on it and never outlive it.
Yeah, it's that peace of mind. It's the latter part, I think, is what they're looking for first. We use all the other technical terms in the front end, but yeah, I think when we talk to participants, this is exactly what's on their mind. And like I said, the biggest part of the demographic curve here is upon us, and this is what's on their mind, and it's going to change. Just as the baby boomers have changed everything they touch, they're going to change this industry as well. We're there.
You're going exactly into the two cases that I want to just bring up and chat just a little bit about. You and I talked about this before. I want to preface this, and this, that just because somebody bring up a lawsuit in this country, anybody can sue anybody anytime they want. That's apparently the beauty of democracy, or rule of law, or what have you.
Yeah.
But it does not mean that any party who's being sued is guilty. I mean, they are innocent until they are proven guilty. I have read the case on both cases, the both complaints. I think I'll bring up the first one, which has been around for a couple of years now. And this is the case where a record keeper, a TIAA, is alleged to have violated a conflict of interest, where, I guess, lack of a better word, cross-selling of services. TIAA is a very unique organization. It's been around for 15 years or 105 years, something like that. And they started life not under ERISA. ERISA didn't come in until 1975. They started life as a insurance company that's trying to provide for teachers and professors in schools. And they did that through individual contracts between the professors and TIAA. As the industry morphed, they tried to retrofit this approach into the new age, and very clumsily, quite frankly. The lawsuit, the class action case, alleges that they were cross-selling services where they are very similar to what you do with TRPC. They are the record keeper. They provide the investment under those contracts. Apparently, according to this lawsuit, that the company decided that they're going to offer, very similar to what you also offer, is individual advice, or wealth management is what it's called today, to participants with an account average of more than X, because you're typically looking at a larger account in order to really be impactful and make a difference.
Mm-hmm.
And of course, when you do that, there's additional services, and of course, additional services is additional fees. And so the case is alleging that TIAA, being a fiduciary, is not serving in the best interest of the participants. Not as a fiduciary because they are a record keeper, but they are a fiduciary on the investment side, and they also is a fiduciary on the participant side. The fact that they were right or they were wrong, or they would be proven right or wrong, it remains unknowable, because I don't really know what the other side of the story is, as you would think, right? Regardless they win or lose, it shine a light towards a situation where record keepers wanting to do the right thing for participants, because the participants and plan sponsor trust them, that what do you think will there be a cold blanket over all this cross? I don't even want to say the cross selling. I mean, let's say you're not even selling anything. One of the participants come to you and say, Todd, I got to know you. I really love the investments that you do for us. We want you to help me on an individual basis. Do you think we'll put a wet blanket on this?
I mean, very likely it could. I mean, there's no doubt about that. This is such a multifaceted, complex topic that you and I have talked about over the years. I've talked about it with colleagues and people in our firm, outside of our firm. We live in kind of two worlds, right? The one world we live in is the world that we interact with every day, where we really take to heart the role that we're serving in, and we really want to just do the best and do the right thing. That leads us to be good listeners and to think before we act, hopefully. And even in those most cautious moments, it doesn't mean that we're doing it the right way. So we and a little different than this provider, and a little bit different market. We tend to work in the private sector, generally for 401k, less 403b. And while we do provide all these services, we are kind of bundled, but we are also able to provide a lot of our services unbundled. The vast majority of the clients that we provide record keeping services, for example, to, we're not the advisor. Mm-hmm. We can draw the line between fiduciary, non-fiduciary, quite bright in the client's eyes. But in cases where you're providing all the services, things get very mushy and indistinguishable very fast. And I think that just from a device standpoint, I think we've always taken a very slow and measured approach, a more cautious approach, whereby I think the rules are pretty clear. If you're asked and you don't solicit, you're able to provide services in a cleaner way, not perfect. Doesn't make it bulletproof. If you solicit, the standard is much higher. The expectations of duty and loyalty and prudence and all the fiduciary best practices really, the bar goes up very, very fast, and you need to be prepared for that. So, I think this will be an interesting case that will determine how high the bar went, and where's the preparation there, and were all the protocols in place. Hopefully they were, and if they weren't, and this looks like what's going on in other places, then the wet blanket could come out real fast, and I think everyone there'll be a pause for sure.
So I'm going to build a bridge from this case to the next case, and part of the discussion is over the last 20-25 years, one trend has been clear: is cutting fees. Controlling plan expenses is an important fiduciary function, because if you are managing or responsible for somebody else's money, you want to make sure you don't waste any of the money on fees. I mean, that's a very simple concept. Number of reasons why it has happened. One of them actually is lawsuits against many, many plans over the years, and really focused on fees even more than it should. Because of that, these organizations, record keepers or what have you, I mean, actually across the entire industry, I'm talking about record keepers, asset managers, intermediaries like advisors and consultants, and everybody in between, and see their fees being compressed. But at the same time, you have just the recent two sets of laws, 2019 Secure 1.0, then 2021 or 2022 Secure 2.0. It has a lot of expectations of the record keeper. And it's not free. I mean, the record keeper spend, you tell me, I mean, hours and hours, both from a compliance standpoint, as well as tweaking your operation, your front line, your back office, your technology, everything to comply. Who's paying for that? Mm-hmm. Certainly you are first paying for it, but how are you going to get that money back based on what you pay? And that's another conversation, because most plan sponsors don't understand it. The bottom line is There's an increased cost, ongoing cost, inflation, headcount. There is a squeezing of revenue. Just kind of burning on both ends. If I understand the industry, we got to find, if they're going to stay in business, they got to find another revenue source. At least this is allegedly the case. And many of them find it through two ways. One is cross-selling is what is being alleged. Saying I just do more for the same client. I don't want to leave any change on the table. The other is find new services I can include.
Right.
And so now I'm going to bridge to the next next case, which is a class action suit about it wasn't against Empower, but it is about Empower being the record keeper, offering managed account as a service, and to make available managed account in this particular case as a qualified default investment, meaning that everybody who are not willing or not able to give you investment instruction to what to do with their money will automatically be in managed account. Tell us a little bit about your understanding of that case, and let's talk a little bit about if that is a wet blanket on that as well.
Yeah, there's a big windup, and there's a lot to unpack there, Philip. Let me see if I can come at it from a few angles. One, there's no secret that fee compression is a real thing in the retirement plan business. It's primarily impacted, I think, the record keeper. Certainly, asset managers have felt it to a meaningful degree. The investment advisors, everyone is being asked to do it for less.
Right.
And to your point, do more for less. Now, the fees were too high. We need to work on the fees, which I think the industry did move definitely down. And interestingly, why is it the focus on fees? Well, the regs talk about lots of things. Fees are just one of them. But I think the fees are the universal thing that individuals can conceptualize. It's hard to conceptualize testing or compliance testing or what have you, alpha and beta and Sharpe ratios on investments. But if you want to talk about fees, fees are universal in life. So they I think it was intended, it was rightfully addressed, but I think there's a bit of a hyper focus, which it's fine. But as you think about that, as the fees were coming down, technology was expanding. The research, again, in this relatively nascent industry called 401k was coming out as to what works, how do we move the needle, how do we get better outcomes for participants. We want to educate. Yeah. We don't want to just educate them. We want to actually broaden that scope. We want to make sure they are not only just saving for retirement, but they have financial wellness, right? Much more holistic. We got to be the many more services along the way. We need to make sure this is a emergency savings account also now, right? We need to make sure we're matching the money that you're putting in your plan because you're paying your college loan back. I mean, now I'm a tuition repayment, facility. There's so many things we're being asked, and really there's also the things that we want to do that we know will benefit participants, which are, hey, we live in a world where there's technology. Technology can be very powerful if harnessed properly. We can take the data that you've already been giving us for decades, and we can now apply it to your investment account in a way where you don't have to get engaged and you don't have to be an investment professional. And we can work, the solutions can work towards a better outcome. This was the DB experience, right? You tell me how much you're going to need and when you're going to need it, and we're going to manage a portfolio of assets that will provide that benefit when you get there at that date. These are parallel concepts, and I just think that people kind of have to decide, right? Do they want the stuff or do they want the inexpensive? Because you can't have both. And so I don't per se begrudge those who are in the middle of this case, but like everything, there's a limit. And I think this is why we have a court system. This is why we have, a process, and we'll have the discovery and we'll learn from it. So, again, hopefully this was done with good reason and good measurement. I think we all know that there's no requirement that, it be the least expensive, whatever it is, for fiduciaries to be protected. It's all about what does the fiduciary want, what do they expect, and do they think the value is consistent with the service they're receiving. If they do, then they can deem fee is reasonable, regardless of whether they are the highest, lowest, or somewhere in between. So, I think this is just another test in that type of equation that we're going to get some answers to, and hopefully all be better for.
And I know by now, since 2006 Retirement Act, most participants are not engaged. In other words, they are barely good savers. We want to make them great investors. It's expecting too much. Most people are very busy in their lives. They don't have time to always think about, hey, should I be tweaking this? Should I be investing in that? So studies over and over have found that they're just not engaged. So that's why 2006 plan that talks about auto enrollment. Just enroll them.
Yeah.
And then basically forcing them to save. And they do save. If you force them to save, take money out of their paycheck and 1%, 2%, 3%, and so on and so forth. And then on top of that, every year it goes up through auto escalation. That has been a winning formula. I think the latest Vanguard annual study shows how many people in these sort of multi-asset, you can call it whatever you want to call it, target date fund or managed account, whatever, portfolios is because the default. And the assets have grown a lot. Why? Because people are starting defaulting them and escalate them over time. So that has worked out well.
Mm-hmm.
Now they say, well, gee, if it has worked out so well, why don't we put personalization into it? Meaning that, Todd, let's say you and I are the same age. You are a great saver. I'm a terrible saver. You make more money and I make less money. Your situation is different than mine. We shouldn't be all sitting in the same asset allocation, same portfolio. With that information they have of you, they should be able to personalize to make it more a Todd portfolio rather than a Philip Chao portfolio.
Mm-hmm.
Makes perfect sense.
Yep.
The lawsuit against Bechtel is that they have replaced a target date fund, which is a fairly low cost, you and me, same age, will be in the same portfolio, to a managed account. You and me, not at the same age, or even at the same age but different circumstances, will be the portfolio will be personalized to you through what they call a managed account.
Mm-hmm.
The problem is, apparently, most of the folks still are not engaged. That didn't change the engagement aspect. And so if you're not engaged, the personalization is significantly reduced. Not that there isn't any, but it's not as much as somebody who says, hey, by the way, I have money from the last employer I didn't put in here. Did you know I have my father-in-law died and gave us a rental property? I get $1,000 a month. Whatever. All that information is not included. So it was very limited personalization and no involvement. And yet, on top of that, managed account, as you can tell, as you know, is supposed to provide you a lot more quote-unquote services or more specific service for you. And as a result, it costs more. So the lawsuit suggests that since most people are not engaged, we're not seeing any value, and you are forcing everybody to pay more, that's not a good fiduciary. What's your thought about that?
If you talk to plan sponsors, if you talk to participants, I think that the reason why target date funds, default solutions, QDIA provisions, automatic enrollment, automatic increases. Yeah. The reason why they've been so massively successful as a service is because it meets the participants with their expectations. They were never hired expecting to become investment professionals. They don't have an interest in it, but they often desire to retire.
Yeah.
I look at it from the standpoint of, from an industry and from a regulatory standpoint, how do we put people on a path that we think is a good path, a solid foundational path to hopefully get them to a meaningful and dignified retirement? right? And if they want to come off that path, they're free to come off at any time. This is America, the land of the free, and they can come out at any time, and they should be able to do that. No one should be required against their will, or at least that's a common wisdom. But we do want to we don't want to make them hunt around in the dark for this path. Let's make it easy as possible for them. And like everything, what looked easy and what looked best 30 years ago, when the target date fund came out, things improve. And so I think there is a reasonable discussion to say, have we moved the needle far enough through a personalized service, through a managed account? And we use this language like it's a one size fits all. Of course, there's so many different providers and so many different iterations of this. It's for sake of conversation, we can shortcut it. But doing that homework as a plan sponsor, finding about is that the fit for my population, understanding what you're buying. They are the customer on top of their participants, and kind of working through this. There's a way to do it, and I do think there is a way to meaningfully move the bar to benefit the participant and put them a more exact path for themselves. I think there's a reasonable way to incorporate that into a plan. This one, I don't know what the details were.
Yeah,
I don't know what the process was. I don't know how that unfolded. So I could easily make a case. This is perfectly fine, or there was something nefarious. Who knows? This is just an allegation. But again, I think it will help inform us either way.
Yeah.
Because I do think this is the trajectory, right? I mean, this is the path that everyone wants to solve for, a more precise path, a more personalized path, like you said, the Todd portfolio and the Philip portfolio.
When you think about the second case, which is the Bechtel case I was referring to, it talks about how I believe the fee went 7 times more than what it was. 7 times.
Yeah.
What I think I can say without making judgment is that whoever the fiduciary is, if indeed those facts are true, so all these caveats, that what is that prudent process and how did you assess value? Is that a good value for 7 times or 6 times? I mean, a significant increase of revenue to the record keeper. And this happened to be Empower. Empower just happened to be the one. It could be anybody else. I'm just using that as an example in this particular case. And so I think at the end of the day, when you look at all the stuff, cross-selling, doing the right thing, not doing the right thing, alleged not doing the right thing, the fee, the increase in revenue to an advisor under a advisor to a managed account environment where they're supposed to add value to it, or under a dynamic target date fund and managed account environment where they start out life in a target date fund and then at a certain age automatically goes into a managed account and bump up the fees, because there should be a difference, right? Because you're doing a lot more and it is costlier. All that, I think, is really go back to the central responsibility rests on the fiduciary.
Yes.
Do you have a prudent process?
Yes.
How did you make that decision?
Yeah.
Did you go out there and do an RFP, a request for proposal, and look at all the reasonable solutions? And how did you come up with and make your decision and select? After all that is still not enough. Did you control the expenses? And did you monitor the effectiveness, right? So you assume that it's great. It all sounds good. There's the Todd portfolio and Philip portfolio, but Todd and Philip, neither one of them at the same age, happen to make the same money, put in any more money, put in any more information. Mm-hmm. If that's the case, you and I are practically on the same glide path, on the same target date fund. So I think that's really what I'm learning from these cases, plus what the fiduciary rule is saying. By the way, you can do all these wonderful things and control all that. One day this person retires, the gate opens, right? The money flows out, and good luck, buddy. Here, have a good life. Yep. So at least that's how I think about it. I don't know. What do you think? What do you think, Todd?
Yeah, these are definitely the undercurrents that are going on. I think kind of the beauty or the elegance in the regulatory side that we have is one whereby there is not a one size fits all out there.
Yeah.
Um, you know, it's process oriented. It's facts and circumstances. It's value for cost, and there's a spectrum of appropriateness. It's just about conscious decision making versus making decisions otherwise or haphazard or what have you. And certainly the numbers in the Bechtel case are the numbers are big. I mean, how can they not be attention grabbing? But I think all of these finer points, this is where the court system will kind of help us figure out what is the upper and lower tolerance for this regulatory environment. And in the case of the TIAA, how do we find that balance so that as our clients need things over time, we can provide them to them in a proper way. But I think you and I have talked over the years many times. I think nothing's foolproof way of doing business, but when you really start from the end and you work backwards, and when I say the end, the participant, if you start there and you start thinking backwards and building your process and building your decision making from that angle, you're much more likely than from the my side of the table. What's in it for me, right? And I think that's really what the regulatory agencies want people to frame through, and it's a living, breathing thing, and greed is real, and it does present at times the desire to do more and do better and hold the highest standard. That exists as well, and there's always a tug of war to some degree, sometimes consciously, sometimes not conscious.
Don't even know I'm offending the rule.
Yeah, you don't realize it, and so there's got to be someone out there to call fair and foul, and keep the system moving in the right direction. So, fascinating cases, super timely cases. Taking the half full approach. Hopefully we get good information out of these that helps us all be better practitioners, service providers, and really operate this ecosystem in the best way and to the best outcomes, because there's a lot of people that are at a very vulnerable point in the industry right now, from a participant level. Again, going back to this demographic story, they're unprepared, they're uncomfortable, they're looking for a lifeline, and there's a lot of people out there looking to help. And unfortunately, there's some actors in there that are looking to take advantage.
Sure.
And it doesn't take many of those to upset the apple cart for those that have the right intentions. Not to say they're going to be perfect in their actions all the time, but this is going to be a really interesting set of cases to frame and learn from.
Survey after survey, employees continue to say, we trust our employer, we rely on our employer. And that's wonderful.
Yeah.
And I think because of that, the employer in this case is the fiduciary, is have a heavy burden.
Yeah.
And finding the right advisor and finding the right thing is also a challenge.
And you think about certain parts of our industry, the largest end, you hope they have the resources and the personnel to address these things in the most complete manner. But the reality is that, as we know, the population of retirement plan sponsors are really the small employers and the medium-sized employers that make up all the masses, and they really never got into business to be a plan sponsor. They want to do well. They hope, but they want to run their business, and they really got excited. They get excited every day waking up about thinking about their business, a little less so about their 401k plan or their retirement plan. And they need people to help, and they need to be responsible to a degree. But I think also it would be helpful if there could be more protections for plan sponsors who really, unfortunately, are kind of at the intersection of what is getting a deeper and deeper pool of requirements and risk and protocols that they need to be familiar with and manage along the way. It's not easy.
We don't get to talk about these type of things too often. We always end up talking about business or the industry, but But this type of thing is really vital, really important. And we should self-reflect what we are doing. Are we doing the right thing for solely for the interest of participants?
Yeah, thank you for having me, Philip. I think, conversations are important, like you said, and these are good topics to sharpen our skills and try and do better.
Exactly. Well, thank you again, and look forward to talk to you again soon.
Great. Thanks, Philip.
You can always find more episodes by visiting philipchao.us/podcast or find us on your favorite podcast app. You can always leave us feedback, ask questions, or request a topic for us to discuss by sending an email to pc@philipchao.us.
Views expressed in the Tao of Chao podcast are individual opinions, and they do not represent the employers of each guest or the firm each guest is associated. Our podcasts are for educational and informational purposes only and should not be deemed or viewed as investment advice or recommendations. Please consult your personal financial advisor, investment expert, or investment fiduciary before taking any actions about your plan and investments.